Hello, this is Kim Clark.
Hi, Miss Clark. This is Marc Stevens. I'm going to connect in a moment.
Okay, great.
All right, just hold on.
Hello.
Yes, see if we should be able to get you guys connected here now.
Okay.
All right. Okay, Miss Clark?
Yes.
Okay.
Yes, I'm on the line.
All right, we're all on.
Good.
Great. Okay, and Mr. You're recording this call, is that correct?
That's correct.
Okay, so I'm just going to do a few preliminary things first. This is Kim Clark. It's December 15th, and this is a telephone conference call with docket number 1726-08L. Mr. Could you identify yourself?
This is...
And we also have on the line Marc Stevens.
That's correct.
And Mr. Stevens, are you Mr. Jackson's representative, or are you just on the line?
I'm his representative today.
Oh, okay, so are you a CPA, or do you have a power of attorney?
I have a power of attorney, yes.
Okay, for Mr.
Yes.
Do we have a copy of that power of attorney on file?
No, I have not sent that to you.
Would you be able to fax that to me?
I can. You mean right now?
If possible, yes.
Well, I can't. No, I don't have a hand right at the moment.
Okay. Well, I just want to get verbal confirmation from you, Mr. Today we're going to be discussing your personal income tax information, and I want to make sure we have authority to disclose that information to Mr. Stevens.
Yes, you do.
Okay, great. Oh, I think that is the preliminary information. I just wanted to make sure, given our disclosure regulations, that we could discuss your income information. The purpose of this meeting is to prepare this case for trial. As you know, we're supposed to agree on all the facts that are not in dispute and submit something called a stipulation of facts to the court, which includes documents and any facts. It would include copies of your administrative file if you're willing to stipulate to that. Do you have any documents that you're planning to introduce at trial, Mr.
Well, at this particular time, Ms. Clark, we wanted to discuss first as far as what you're planning to bring and what you've gotten in the informal discovery request was not responded to. So if we could start with what facts and evidence and witnesses you rely on, that would get us through this quicker. We could save a lot of time.
Okay, so first of all, we have the administrative file, and our position is that at least for 1999 through 2001, the court should be reviewing our determination under an abuse of discretion standard. So we want to admit the administrative record to show that there wasn't an abuse of discretion. And, of course, that would be necessary if Mr. Jackson was arguing that there was an abuse of discretion. Because if the court doesn't have anything to review, they can't determine whether there was or was not an abuse of discretion. And we sent a copy of the administrative file to Mr. Jackson last January or February, I believe. The next thing, if you're planning to dispute any of the income that I discussed in the Brannerton letter, I'd like to know that just really fast.
Well, I think what's in dispute is the issue of the taxable income. So which witnesses do you rely on to prove that Mr. J is a taxpayer under federal tax law?
Witnesses?
Yes.
We're not planning to have any witnesses unless Mr. is not going to stipulate to the administrative file at this point. I mean, that may change by the time we do our trial memorandum, but at this point, we don't have any witnesses to call.
So you don't rely on any witnesses to prove that Mr. is a taxpayer under federal law? This is just your opinion?
Mr. Stevens, this is not an opinion. We're discussing whether we're how we're preparing the case for trial. I'm not planning to call any witnesses during the trial.
Okay, so all right. I'm just trying to verify this, and so that we understand. So if paperwork is filed in court, there's less of a chance that you're going to think we're taking your statements out of context. So you're saying that at this point, and let's just discuss this freely as if we're not actually going to trial. Do you have any witnesses to rely on to prove that, with personal first-hand knowledge, that Mr. is a taxpayer under federal tax law?
I can see where you're going with this, Mr. Stevens. As far as relying on witnesses with first-hand knowledge that he's a taxpayer, that determination was made in the administrative file, and we're relying on third-party information, which was reported to us by several payors that gave reported income to Mr. during the taxable year of 2002 at least.
So let me ask you, is there someone in this administrative file that will be identified as a witness with personal knowledge that Mr. is a taxpayer?
The administrative file lists all of the people who made determinations along the way as far as the notice of federal tax lien and the notice of intent to levy.
Okay, would they qualify as witnesses with personal knowledge that Mr. is a taxpayer under federal law? I mean, would you feel comfortable calling any of those people as witnesses that they're qualified to testify against Mr. and that he's a taxpayer under federal law?
Now, if we're going about the definition of a taxpayer...
No, I didn't ask you that. No, I didn't ask you that. I'm talking about a witness with personal knowledge that's qualified to testify in court that Mr. is a taxpayer under federal tax law. I didn't ask you about a definition. I'm just asking you about if you have a competent witness to testify against him.
Well, if we're having competent witnesses testify against him, then we're preparing for trial. And I am not planning to call witnesses at trial at this point.
Well, at this particular point, what we're trying to establish is that you don't have any witnesses, so that when you call in your paperwork, when you refer to Mr. as a taxpayer, you're doing that based on your own knowledge or it's your own opinion. It's not actually based on a competent witness that you can rely on at trial.
Yes, and this is something that you can make arguments to the court about. But at this point, we need to discuss preparing for trial.
Well, that's what we're actually doing. So do you have any witnesses with personal knowledge that Mr. Jackson has taxable income under federal tax law?
I'm not planning to call any witnesses.
Oh, okay. So just to clarify, you see, there's a fine distinction here. I don't want to be accused of having Mr. be accused of taking you out of context when you say that you're not planning on bringing any witnesses, and then we bring into court that you don't have any witnesses, and you say, well, no, I didn't say that. So I need you to clarify. Do you have any witnesses that you rely on, at least during the pretrial stages, to prove that with personal first-hand knowledge, to prove that Mr. Jackson has taxable income under federal law?
At this point, I'm going to say that this is going to be a frivolous argument, and I'm not going to discuss that during this pretrial conference.
What frivolous argument are you talking about? I'm asking you a question. What are you leading to?
I think at this point, I'm going to need to end this call.
Why? I don't understand. I'm asking you for witness. I'm asking you basically what witnesses you rely on. You think that's frivolous?
I'm not relying on any witnesses at trial.
Okay. Are you
relying? We have documentation from third parties that has stated that Mr. received income from them.
Okay.
These years, and I'm trying to determine whether he received that income, and then we can argue whether it's taxable in front of the judge.
Well, I don't think we need to do that. We're trying to maybe possibly avoid trial. If you don't have any witnesses with personal knowledge that he has taxable income, because the third parties didn't determine that, that was had to have been sown at the Internal Revenue Service. If you don't have any competent witnesses to rely on, and Mr. has taxable income, then you could just say that. That's not frivolous. The last time I looked, asking for witnesses that were competent to testify has never been determined to be a frivolous argument. And if you believe to the contrary, you need to cite a Supreme Court case that actually lays that out, because that would be a huge shift in American law. We just want to know specifically, do you rely at this point in the pretrial on any witnesses with personal knowledge of Mr. J. had taxable income? Hello?
Sorry, I was just trying to think of a response that would, at this point, let's see. what you're trying to get at.
Well, I'm just trying to get at if you have witnesses with personal first-hand knowledge that he has taxable income. That's what I'm trying to get at. I'm not making an argument. Mr. isn't making an argument. If it comes out that you don't have witnesses with personal knowledge, we'll make an observation to the court, not an argument. We will let the court know that you don't have any witnesses with personal knowledge to support your accusations against Mr. That's not an argument. That's an observation based on what I've said to you. So
yeah, I see where you're coming from.
Yeah, I'm just asking for witnesses. That's all I'm doing. I'm asking if you have witnesses with personal knowledge. There's no ulterior motive here, Ms. Clark.
Well, as far as I know, there aren't any at this point. I'm just going to say at this point.
There aren't any.
Not that I'm planning to call during trial, and not any that would... Okay, so what I'm trying to say is that at this point, I'm not planning to call any witnesses that would have firsthand knowledge that he is, in fact, a taxpayer under the code.
And taxable income.
Well, as far as taxable income goes, we've made that determination.
Well, I understand that. And that's
I don't know who filed the substitute for return at this point, and so I can't say that. Whoever did the substitute for return determined that he had taxable income. Okay,
do you want some time to get with the Internal Revenue Service to find out who that individual is?
Well, I can find out. I'm actually looking into that right now.
Okay.
So, I've made inquiries.
Now, if a subpoena was to be issued, would you fight or move to quash a subpoena for the agent who did the assessment to appear at trial?
Yes.
On what grounds?
At this point, that it would be unnecessary.
So it's not necessary to have the actual person who did the assessment testify under oath to its veracity?
Well, let's just say I would object.
On what ground?
At this point, I don't have grounds at this point, but we're going to object if you try to subpoena the person who did the substitute for return.
Oh, but you don't have any grounds at this, any legal grounds to make. Why would you want to oppose that? I would imagine that if you are relying on this unknown individual who made this assessment that you think is valid, I would think that you would be subpoenaing, bringing them into court yourself to bring into court, put him under oath, and prove once and for all that Mr. is a taxpayer with taxable income. Why would you oppose that? Why would you oppose actually making a case? I mean, what you're saying is like a prosecutor who has a traffic ticket, and if I'm the defendant and he's accusing me of speeding, and I subpoena the officer to come in and testify to verify his complaint and his that you as a prosecutor would fight that. I would hope to think that the judge would have the integrity to then throw your ticket or your assessments out. But again, I'd like to know why you would fight against having your own witness on the stand. Well, at this point,
now that you said it that way, I don't know whether we would or not.
Oh, okay.
I'd have to determine, I'd have to see the subpoena first, and then we would make a determination on whether we would move to quash it.
Yeah, it's kind of odd that, you would...
Well, I'm saying it's very possible that the person is no longer with the service, or the person is on the other side of the country. So, I mean, at this point, we would have to see. Oh, okay, I understand. So now, do you have any witnesses that have personal first-hand knowledge that Mr. J. was required to file a tax return on the federal law? Okay, I'm not going to discuss that question. That question was in Mr. J.'s repeated request for discovery. Yeah. And he filed it with the court, and the court said I don't have to answer those questions at this time. I'd like to discuss what I sent Mr. in the mail, the Branderton letter, requesting documents from him. Does he have any documents to support any expenses or anything for 2002? Well, as far as I know, the judge had mentioned that we can ask for permission, get leave of the court to submit the discovery again, and we're here today to possibly avoid trial or to narrow down the issues for trial. So if you don't have a witness with personal first-hand knowledge who's required to file a tax return, that would be some facts in dispute.
So I think it is relevant and something that we need to answer today. I mean, it's no different than the answers you gave me on its previous two questions. If you don't have any witnesses, okay, just say it. If you don't know who it may be and they may be on the other side of the country, fine. Let's just be upfront, exercise some good faith, and just say it. We can move on.
Okay, so what was the question again? The
question was, do you rely on any witnesses with personal first-hand knowledge, and Mr. is required to file a return under federal tax law?
That would be the same person.
That would be the same person, so we don't know who it is?
Nope.
Okay, he's unknown. So do you really think you have that strong a case when you're relying on an unknown witness that you've had probably no contact with until at least before today?
Well, the courts have allowed us to do substitute for returns for years where a person had taxable income that was reported to us by third parties. We prepared substitute for returns. We've issued Mr. a notice of deficiency. That was his chance to dispute that underlying liability.
That's not what I asked.
We have 1 year he can dispute the underlying liability, and I'm trying to determine whether he disputes any of that income at this point.
Oh, we'll get there.
Whether he's a taxpayer required to file a return. Those are arguments he can make to the court.
Well, no, we're actually asking questions, and that didn't answer my question. What I was asking you is, as an attorney, representing the commissioner, do you believe you really have a very strong case against Mr. when you're basing your opinions on someone you've had no contact with and you don't even know if you can call them for trial?
We're basing our determinations on information provided by people who gave Mr. money in 2002.
But that's not you're not answering my question. My question is, do you really believe, from a legal sense, you have a strong case against Mr. based on the fact that you have no witnesses that you're aware of, you've had no contact with this individual, you can't give a name, you can't even give a location. So based on that, do you really think you have a strong case against Mr.
Yes, I believe we have a very strong case against Mr. Jackson.
Oh, well, let me just ask you, if Mr. was talking about witnesses that he relies on, but he can't tell you the names, and it shows that your case is absolutely frivolous on its face, would you really be concerned about that? And would you think he was really bringing a valid issue to the court? I'm basing my entire case that the IRS is absolutely frivolous off of witnesses who may or may not even be here. They may be across the country. We don't even know where they are. But their case is frivolous because these unknown individuals said so. I mean, would you accept that from Mr.
I would tell him to take it to the trial, which Mr. Jackson is doing.
You would actually think that someone bringing a paperwork and a pretrial claim of that your case is frivolous based off of testimony of witnesses we can't even contact. We can't even name at this time. We have these unknown witnesses. They say your case is frivolous, and who are they? We don't know who they are, but your case is frivolous. You really think that's a strong position to come from? I mean, we're at pretrial, and what you're telling me is you're basing this whole thing really off the testimony of a witness that you can't even say at this time has any personal first-hand knowledge, and Mr. is a taxpayer because you had no contact with this individual, right?
You know what? I'm going to end this call right now.
Well, there's no reason to do that.
I think that there is reason to do that. You are trying to get information to assert frivolous claims. I told you we're not planning to call any witnesses during trial. We have documents that we're planning to introduce, and I need to know whether you have any objections to those documents, and if you're planning on introducing any witnesses.
Well, Mr. Jackson would definitely object to anything that you're putting in as evidence, especially since you're not calling any witnesses to verify that. But I need you to inform.
Well, if Mr. Jackson is going to object to the administrative file, we will plan on calling a revenue officer or a settlement officer to verify that it is his administrative file.
Okay, but can you identify what frivolous argument you think that Mr. is putting forth?
There are several of them, and I've told him what they are in previous correspondence.
No, you've actually quoted court cases that when you did quote them, you never actually cited the argument within the case. And if you go through the case like Mr. Jackson and I did, we pulled the arguments out, but Mr. Jackson isn't making any of those arguments. Mr. Jackson is not arguing that he's not a taxpayer within meaning of statute. That's not what he's claiming. So could you just take a moment and identify one of the frivolous arguments you think Mr. is putting forth? I think that if you believe you're on solid ground here, that he is making frivolous arguments, I think you should be able to take a few moments here on the phone during a pretrial conference and identify what the frivolous argument is you think he's making.
Well, first of all, I think he's making a frivolous argument in saying that he's not a quote-unquote taxpayer underneath the code.
Okay, do you understand that's not what he's claiming?
That is what he claimed in his, well, okay, let me take a step back. That is one of the things he claimed in his underlying appeals conference correspondence. At this point, the issues for trial are what he set forth in his petition, that he didn't receive a face-to-face conference, and that was an abuse of discretion, and that we didn't provide him with documents for his request.
But you understand
also the underlying liability for 2002. Now, we have documents we're planning to introduce at trial, and that's basically what I have at this point. Like, we can schedule another conference if you'd like, but I'm not going to discuss these items that you're setting.
But you're trying to claim that he's making a frivolous argument that he's not a taxpayer under the code when he's not making that particular argument. That's an Irwin Schiff, Sloan tax protester type thing. All he's doing is putting forth that we've asked you questions on witnesses and evidence, and you've refused to respond. And today, at least, you're being honest and upfront and showing some good faith that there aren't any at this point, which is what you said.
Well, we have evidence. As far as witnesses go, those are yet to be determined, and at this point, it's my discretion to call witnesses at trial. And I'm not planning to call any at this point.
Well, I understand it's your discretion to do that. We just want to be able to identify them and see if you have them. Well, one, to see if you do have them, see if they actually have this personal knowledge to prove he's a taxpayer and his taxable income. You could call who you want at trial. Mr. has the opportunity to do the same thing. So he would need you to identify who they are. That's why he was asking you, and you refused to respond before. I mean, I'll give you a little bit that part of it, you may not, you feel that there were legal grounds you didn't have to answer, but to dismiss the entire thing, to think it's frivolous to ask for witnesses and evidence, that was just way too far. We're trying to avoid trial, and then if we have to go to trial, we have to know who to call. So that's why we're asking you who these witnesses are, if any. But you haven't been able to identify them at this point. But I think you need to, but you said you're going to go through, you're going to do the research and find out. So if Mr. has to subpoena them, then he's able to do that. But you said that there's evidence. What evidence do you rely on that he had taxable income as opposed to income?
As far as taxable income, we have gains from the sale of stocks and bonds, which is taxable. We have
wait a moment. Wait, just a moment, man. We're not. He's not disputing whether there was necessarily income. What he's disputing is that there are facts to show that the income is taxable.
Okay, well, that's another argument you can make, whether it's taxable or not. But I'd like to know why you don't believe they're taxable. Because
we've been asking for facts and witnesses to prove, and you don't have any.
Okay, so what's your argument that gains from sales and stocks and bonds are not taxable?
Well, it's not necessarily an argument. We're saying that there's no facts. So let me ask you, is there a factual difference between income and taxable income?
You know what?
No, this gets right to the heart of the matter, Miss Clark. Is income and taxable income factually identical?
Income is included unless it's excluded.
Okay, yeah, but
exclusions are provided in the code.
I'm not asking about the code, I'm asking about the facts. I'm saying factually, is income and taxable income factually identical, or are there factual differences?
Okay. There are factual differences?
There are. Well, let me write this down. Are factual differences. Okay, do you know what those
Depending on what the code says, and you know what? This has gone too far. I'm ending this telephone call right now, and I'd be happy to set up another conference if you would like to discuss the real issues of this case and not set forth these kind of arguments.
I'm not putting forth an argument, Miss Clark. I'm asking you if there's a factual difference between the two, and I don't understand why you're getting upset after you say no. I mean, after you admit that there are factual differences. This is getting right to the heart of the matter. We're not arguing law. We're not arguing interpretation. There's not an argument here. I'm asking you questions based on the facts. Now, if you think asking for facts is frivolous, and that's fine. You may think that way. I've spoken to enough U.S. attorneys and IRS lawyers that you think that when we challenge you on the facts, you think that that's frivolous. I get that. You don't like being challenged. I get it. But that's something you would have to put in a pretrial report. You would, we have no problem with your opinion that asking for facts is frivolous. We get it, but make that part of the pretrial report. I don't think that that's what you actually believe, though. I've spoken to enough. I don't think that asking for facts is frivolous. Unless you're trying to maintain that the IRS has an irrefutable or irrebuttable presumption of correctness. Is that something that you're putting forth?
I'm just saying I'm not going to discuss code provisions with you. And
I didn't ask you that.
And I know you didn't ask me that, but the answer is underlying. I'm not going to discuss that. Today is to prepare for trial. What I really want to know is whether Mr. admits that he received these items of income, whether or not you agree they are taxable or not. We can just say their income that he received, and then the court can determine if it's taxable.
Well, what we're trying to get to is...
Because our position is that income is taxable.
We understand that.
If it's just regular income, that is fine. The court can make the determination.
Ms. Clark, we're trying to see if there's a factual dispute here. So you're saying that there are factual differences between income and taxable income. So, in addition, we want to know what those factual differences are, and if they actually are present here and can be proven. This is not an argument about the code. I'm not making a legal argument. We're not asking you what the interpretation is. We're just trying to follow the facts. That's all we're trying to do. There are factual differences. You admitted that much. Now, we need to get to the facts that we used to determine, if any, that the income was taxable.
Okay. I'm really just going to end this call right now. Thank you very much for speaking with me today.
Well, maybe you can write Mr. and we can reschedule another time.
Yeah, I think that would work better. I will send Mr. Jackson a letter, and if you're planning to represent Mr. Jackson anymore, I would like a fax copy of the power of attorney. My fax number is 503-527-2777.
Well, wait, one more. I want to read that back. 503 7277.
Yes.
Okay.
And at this point, because discovery deadlines are looming, if Mr. Jackson is not willing to admit or deny that he received those items of income that I set forth in the notice of in my Brannerton letter, then I'm probably going to issue formal discovery.
You're going to issue for what? I'm sorry?
I'm probably going to issue formal discovery regarding the items of income that I set forth in the Brannerton letter, unless Mr. admits or denies at this point whether he received them or not, because we haven't discussed the specific items and amounts of income for 2002.
Well, we could get to that if you would just...
I want to discuss that right now.
Well, we have a factual issue here, a factual dispute that we need to clarify, and we're almost halfway there. We're almost done.
Okay, well, that's great. At this point, our position is those are taxable.
Yeah,
your position can be that it's not taxable, and then you can make the argument to the court whether there's a factual dispute between taxable income or non-taxable income or whatever. But at this point, our position is those items are taxable, and I need to know whether he is planning to dispute those amounts, the amounts of the income.
We need to. All right. So why don't we'll reset this? Give you an opportunity to identify these witnesses, if any, and then get back together on this.
Okay.
It's very important. I'm sorry?
If I plan on calling any witnesses, I will let you know. Or if I discover witnesses, I will let you know.
Well, whether you plan on calling them or not, to identify whether you have a witness, because you said that someone did this, but they may not be there. But we need a name. We need to know who it is, so Mr. has an opportunity to call them.
That's true. So anything that I'm planning to introduce into evidence, that Mr. already has the administrative file. So he can look through that for any witnesses that he plans to call. And if I have any other documents that I'm planning to introduce, I will send them to Mr. And those will have names of potential witnesses for Mr. if he would like to call them. At this point, I'm not planning on calling anyone.
Okay. All right. Okay? Let us know when we can get back together and finish this.
Okay. Mr. Stevens, Mr. Jackson, there?
Yes, you said you're going to send me a letter with your conclusions here and a scheduled
Well,
time.
I'm not going to send you a letter with conclusions. I've stated my conclusions that the income is taxable. You seem to think that there's some semantic difference, and those are arguments you can make.
It's a factual difference, ma'am. It's a factual
Well, okay,
difference.
that's fine. That's fine.
No,
that you think
it's not
there's
the same thing.
Please, that's your position. This is our position.
Yes, but please at least get it right and not try to make a backhanded comment
Okay.
against.
Well, I
Mr.
apologize. I'm just trying to solidify our positions. Our position is that income is taxable. Your position is that it's income, but it's not taxable.
There's no facts that it's taxable. Please get it right. There's no facts that it's taxable.
Oh, okay.
Because what you're doing is an effort is just to be able to avoid having to overcome the presumption that there are no facts. You don't want to actually address the facts, which is very clear from the fact that you got very upset and want to end the phone call when all I wanted to do was talk about what the factual differences were that you admitted existed. So it's a factual difference. So please do not continue, because you do this in your paperwork all the time, Ms. Clark. You keep painting Mr. as making frivolous arguments he's not making so that you can avoid any mention of the facts. And you're doing the same thing here today. We could discuss this and we can settle this without having possibly to go to trial, but you don't want to do that. You admit that there are factual differences, but for some reason you won't discuss what those differences are. And I think it's because you know that you can't possibly show any factual differences between the two because they don't exist in this case. And that your whole case falls apart because of it. You want to go based on our assessment is correct. We don't want to look at the witnesses. We don't want to look at the evidence. We just want to accuse him of making frivolous arguments, and we don't want to back it up. And that's not coming to the table in good faith. Now, the courts may rule in your favor because we get that. We understand. And that may be because the judges are paid from the money that you collect, or it could just be that people are making incorrect arguments. But here, we're not doing that. And so I would appreciate it if you'd stop painting Mr. as a tax protester or a tax resistor and actually address the issues that he's bringing up. He's making a factual distinction, not a legal distinction. He's not making a legal argument. He's making a factual. He's making a factual dispute. So please stop painting a factual dispute to be a legal argument. There is a difference between res judicata and stare decisis, and for some reason you keep mixing those two up.
Okay, well, thanks for your call today. I will be issuing formal discovery on the items of income because we haven't determined today whether Mr. admits or denies that he received that income during those years, unless he's going to deny right now that he received them.
Well, I thought we were going to have an opportunity to do another call.
I don't think that would be the right word.
Fruitful?
Yeah, I don't think it would be fruitful at this point. So,
well, you know, Mr. Clark, it could be fruitful if you would just stop throwing up this brick wall that you're doing. We're talking about the facts. You've got no legal grounds to stop. If you want to deal with this in good faith and you want to settle this as you're supposed to be doing, then you won't throw up a roadblock and refuse to discuss the matters any further. We're talking about the facts. That's something that's relevant and within the scope of what we're trying to do. There's no legal, moral, or ethical grounds to stop discussing the facts so far. You just don't want to do that. The only thing I can think of is that you know that you have no facts to back it up, and you want to avoid talking about it. You just want to beat Mr. over the head with your frivolous hammer and just get your frivolous. We've determined that there's a factual difference between income and taxable income. Let's talk about that and see if you have those to support the assessments.
okay, I am not going to discuss that.
Why?
Anymore. I'm going to end this call now.
But what are your grounds to do that? We want to be able to show the judge your grounds for refusing. At this point, we can just show it's arbitrary and you don't want to talk about it. Why don't you?
Well, I want to talk about the individual items of income.
Well, okay.
I told you what our position is. You're playing semantics with
No, I'm not. I'm talking.
And this call is over. I'm sorry. You can read the code just like everyone else.
I'm not talking about the code. I'm talking about the facts. You said that you agreed that there was a factual difference between income and taxable income. I want to talk about those differences that you admitted existed, and I want to see if you have them to support your assessment. Okay,
I'm ending the call now. Thank you very much, Mr. Stevens. I will send correspondence to you and probably speak with you later. Thank you.
All right, thank you.